In 1610, a case came before the English Court of Common Pleas. It involved a claim by a man named Calvin that Richard and Nicholas Smith had wrongly dispossessed him from a piece of land. In defense, the Smith brothers claimed that Calvin, who was born in Scotland, had no right to bring an action regarding property within England. Now I know, on its face, this doesn't sound too exciting. It's a case about whether a court has jurisdiction, the kind of case that makes even lawyers' eyes roll back in their heads. But the case took an interesting turn, and one that is important for our story on the higher law. In deciding that Calvin indeed had a right to sue the Smiths in a British court, Chief Justice Sir Edward Coke turned to something he called the law of nature. He described that law this way: the eternal law that God at the time of creation of the nature of man infused into his heart for his preservation and direction. Coke was talking about the higher law. He said this law was unchanging, just like the character of God itself. And he insisted that it applies to all people, everywhere, at all times. Indeed, he said it was part of the law of England in the 17th century. And to prove he meant it, he used this law of nature to reason that Calvin owed a duty of true and faithful obedience to the King of England. That duty arose not because of an act of Parliament. It came from God himself as he embedded his law into every human. So why should we care about a case from 1610? Because it illustrates something very important. Thinking about the higher law wasn't just an academic exercise. It wasn't just something that theologians and philosophers like Augustine and Aquinas thought about. It mattered to the law of England and, as we will see, the law of the United States. The higher law helped shape the law as we know it today. Coke was not the first judge to apply the higher law to the law of his day. For hundreds of years, a core principle of English and American law was that there's a higher law upon which all human law is based. This is particularly seen in the common law, the legal system that for over 800 years defined and governed most legal rights and duties of citizens, first in England and later in the United States. The common law still forms the basis of much of our law today. One of the most important figures in the development of the common law was Henry Brackton. Brackton lived in the 13th century. He was a judge and the author of one of the first treatises of the common law. He, more than anyone, gave the common law its shape and structure. Listen to how he defined law. He said, law is a rightful warrant, enjoining what is honest, forbidding the contrary. This may not sound big, but it is. Law isn't just something that is voted on or enacted. It isn't just a rule put in place by whoever is in power. It's about justice and right. For something to be law, true and valid law, it has to correspond with what is right. It must be consistent with the higher law. Here's an example. In session 1, we talked about Martin Luther King and the civil rights movement. King chose to disobey certain laws to protest discrimination against people based on race. These laws had been passed by state legislatures. They were labeled and published as laws, but they weren't truly laws, as Brackton defines that term. Why? They violated the higher law. As King explained, they were fundamentally unjust. They treated some people as things, as less than fully human. To be truly, fully law, a legal requirement must be consistent with the higher law. Henry Brackton is not the only one who believed this. For hundreds of years, this was a fundamental understanding of the English common law. Let's jump forward 500 years from Brackton to another judge and commentary on the common law, William Blackstone. Blackstone was a judge, Oxford professor, and prolific writer. In the 1760s, he gave a series of celebrated lectures on the common law. He then turned them into a 4-volume work entitled Commentaries on the Laws of England. This work was the most significant statement of the common law since Brackton's centuries before. Although the commentaries were popular in England, they were most influential in the United States. Americans who studied the law before the Civil War learned it from Blackstone. You ever seen that famous picture of Abraham Lincoln standing with an axe in one hand and a book in another? That book was likely Blackstone. Lincoln learned the law from Blackstone's commentaries. So Blackstone was foundational to America's legal development. Blackstone was a strong Christian and a believer in the higher law. He called that higher law the law of nature. He wrote, "As man depends absolutely upon his Maker for everything, it is necessary that he should in all points conform to his Maker's will. This will of his Maker is called the law of nature." What is this law of nature like? It is an eternal, unchanging law of good and evil that God gives to guide our decisions and actions. How do we know this law? Blackstone believed that God wrote this law on the hearts of every human so that we could all know and follow it. But he was also a realist. He believed in the reality of the fall. He knew that sin affects every part of us, including our reasoning. So God also revealed his law of nature in written form, in the Bible. Remember, Blackstone isn't a pastor or a philosopher. He's a lawyer and judge. He believed this law of nature mattered to the law of his day. He famously said this, "This law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other. It's binding over all the globe, in all countries, and at all times. No human laws are of any validity if contrary to this." See how Blackstone agrees with Brackton and Sir Edward Coke, and Aquinas and the Apostle Paul before them. Human law must conform to the higher law. If it doesn't, it isn't valid at all. Human law is subject to the higher law. Indeed, the higher law influenced the direction of English and American law. It helped shape certain legal doctrines. The traditional explanation for the right of self-defense is that the inclination to defend oneself against a wrongdoer's attack is wired into our very natures. Judges historically used the higher law at times in reaching decisions. In England, it wasn't just Calvin's case in the 1600s. In the 1900s, the Court of King's Bench turned to higher law principles to determine that an act of cannibalism committed by starving survivors of a shipwreck on the high seas was murder and not an act of legal necessity. Judges used it in the United States. Here are a couple of examples of legal questions where American judges turn to the higher law. Does the governor of Vermont have the right to imprison a defendant alleged to have committed a crime in Canada? Or who's entitled to unclaimed bales of cotton that washed up on the Florida coast after a shipwreck? The finder or the government? I'm sure it comes as no surprise to you that the belief in a higher law that shaped English and American law for 500 years is no longer the dominant view. This was illustrated powerfully in 1991 during the Clarence Thomas Supreme Court nomination hearings before the U.S. Senate. Today we most remember those hearings for the allegations that now Justice Thomas had sexually harassed Anita Hill. But Thomas's nomination had become controversial even before that, because of his belief in the higher law. Thomas had written an article in which he affirmed this quote by John Quincy Adams: "Our political way of life is by the laws of nature and nature's God, and of course presupposes the existence of God, the moral ruler of the universe, a rule of right and wrong, of just and unjust, binding upon man, preceding all institutions of human society and of government." Thomas was criticized as out of the mainstream and dangerous. So what happened? Why would belief in a higher law be viewed as dangerous? Why indeed did courts largely stop referring to it in decisions? That's a complex story that would take more time than we have in this short video series, but I'll share a couple of reasons. First, some became skeptical about how useful the higher law really is. Not surprisingly, leading up to the Civil War, abolitionists turned to the higher law to argue for the full humanity and worth of slaves, and to argue that slavery should be banned. Perhaps more surprisingly, some defenders of slavery also appealed to the higher law to justify their position. For example, Confederate Vice President Alexander Stephens, in his famous Cornerstone speech, said this: "The foundations of the Confederate government are laid its cornerstone rests upon the great truth that the Negro is not equal to the white man, that slavery's subordination to the superior race is his natural and normal condition. This, our new government, is the first in the history of the world based upon this great physical, philosophical, and moral truth. Now, most believers in a higher law saw this as an obvious misuse of the higher law. But some wondered, if one can appeal to the law of nature to support both racial equality and slavery, how useful is it? There's a second reason as well. The rise in the late 19th and early 20th century of skepticism about the existence of moral truth. This is illustrated well through the life and work of Justice Oliver Wendell Holmes. Holmes was a brilliant, influential thinker and a justice on both the Massachusetts and United States Supreme Courts. He was shaped very much by his experience in the Civil War. He left Harvard just months before graduation to join the Union Army, filled with optimism and idealism. He came home after being shot multiple times, disillusioned. He became skeptical about almost everything, including the existence of moral truth. He argued in a famous article called The Path of the Law that discussing moral principles in law only leads to confusion. He wrote this, "I often doubt whether it would not be a gain if every word of moral significance could be banished from the law altogether, and other words adopted which should convey legal ideas uncolored by anything outside the law." To Holmes and other influential thinkers of his day, law isn't rooted in morality. It's rooted in power. He once wrote, "I am so skeptical as to our knowledge of the goodness or badness of laws that I have no practical criticism except what the crowd wants." Now, certainly not every modern thinker agrees with Holmes, but the dominant legal theories today are rooted in some degree of skepticism about a higher law. Most typically today, law is viewed simply as a means to exert power, or a political tool to accomplish certain social welfare goals. And unfortunately, without an objective standard of right and wrong, without a higher law, might makes right. But don't despair. Higher law has not gone away. There are still legal thinkers who embrace it, and law schools like Regent Law that teach it. Higher law concepts like natural rights continue to shape our law. And as we will see through the rest of this series, higher law principles, belief in eternal truths of right and wrong, just and unjust, continue to break into the mainstream when we veer too far away. As we will discuss soon, we certainly saw this after World War II at Nuremberg and in the start of the modern human rights movement. And it continues to be relevant to many key issues confronting our nation today.